if a custom was repugnant to justice and morality, they oppressed it and in a way tried to erase the same.
The laws that we have
Yeah.
actually not ours. Let me say that they're not ours. Just remember that we have a witchcraft act.
Exactly.
We have a witchcraft act in Kenya.
How do you go to court to prove witchcraft?
Exactly. Welcome to another episode of Afrokin, our kin, our truth, where we dig deep into the African family values, African family setting, and see how that affects our modern life, whether that actually has an impact on us. And today we have a very interesting topic that we're going to look at, and that is who determines your family. Do you determine your family? Does your birth determine your family? Or can the law determine your family? And today we have a legal expert who is going to help us delve into the law and see the covert ways in which the laws of Kenya respond to family issues and whether they actually, at the end of the day, dictate what a family is and who are our family members. For our guest today, we have Beth Moraa. She's a legal expert and a very, very interesting person to be around. So you'll get to see it, and I hope you get to learn a lot about families and what that means for us and how the law interacts with families. So, Beth, karibu sana.
Sante.
Yes.
Yeah.
So, like I just said, today we are looking at who determines our families. And this actually came up because when we're looking at issues of families, African families, and we've had this discussion, I realized that a lot of what is mentioned in the African setting, what is mentioned, by the other guests that we've had, is actually sort of missing in our laws right now. So I started thinking, we have laws that speak on different aspects of, our lives, and therefore, do we have laws that actually speak on family, and how do they impact who we view as family right now? But first, let's go back to the African setting. Did we have laws back then in the African setting? And back then also, did we have systems in which we resolved issues? And how was that like? Because I don't really think a lot of the legal words we see right now are actually very modern. So I was actually just wondering, did we have laws back then?
Okay.
Yes.
Interestingly enough, we did have laws. And this question is often asked from a point of assuming that the fact that maybe our laws were not codified back then or written down, those systems did not exist. But I'm going to give an array of examples of legal systems that existed back then. The Baganda had a chief justice, whom they were calling Omulamuzi, and he basically acted as a judge and decided on issues of inheritance, issues of custody, issues of communal relations, issues of land disputes, and even dispute resolution itself. The Yoruba themselves also had a very elaborate legal systems that had councils of elders and chiefs, and a body that was called Nokbona that also helped in managing issues of morality within the community members. We have the Asantehene among the Asante of Ghana, who had courts, the Asantehene's courts, and also lower courts that handled minor issues in the community. And as you can see, it's almost the same structure as what we have now. The hierarchy existed then as it existed now. Because even for the Baganda, the Kabaka had a court that could handle issues that were of greater magnitude. When you're bringing it back home, we have the Kikuyus had the Kiama, a council of elders, and the very famous ones, the Jurincheke of the Meru. We have seen very influential people from the Meru community still go back to pay homage to the Jurincheke and perform rituals and traditions that are still very relevant even to this day and age. So we did have laws, and we did, the fact that maybe they were not documented as elaborately as our modern laws are does not take away from that. We did have legal systems.
That's also interesting to learn, actually. Now you've reminded me Kabaka and us learning about Kabaka when we were in school. And also that brings me, because one of the guests that we've had is the Luo Council of Elders, who have also just realized in your as you were explaining, were also a form of system for, like the Luo community and how they resolved issues around touching on various issues on African way of living and all that. So now that we had that, or that we've seen that we had the legal systems running, although they're not the same as what we're having right now, how exactly did we get to where we are right now? How did we get to have codified laws, which is, how did we get to have the current laws that we had, from moving from the traditional system where we had groups, councils, kings, and whoever who are discussing or giving us guidance in terms of norms and how to live, to having the very many laws that we have as a country. Yes.
Also, I've just realized codified laws is jargon. So we may need to break that down further.
Okay.
So of course, the legal system that we have now did not happen organically. We were Africans, we had our own ways of living. And as we all know, we're very many communities. And of course, there's similarities, but there are also very key structural differences in how we handle our issues. From the first example, we've seen that the communities that had councils of elders, the others that were very elaborate and even had a chief justice, like the Baganda Kingdom, others just had chiefs, So for us, for the African states, most of our codified laws came from the colonial era. As we know, only 2 countries in Africa were not colonized, which means the remaining 52, actually all of them, we all have traces of our colonial masters in how we do things, from our education systems, our health systems, and even the laws that govern us, and even the governance systems themselves. So in Kenya, for example, how our current laws came to be, when the British came to Kenya, they were running the country on a dual legal system. So that is the British common law and the customary law. So British common law was an almost verbatim adaptation of British laws. And even till today, some of them, if you look at our penal code, they're still verbatim, similar to Britain's penal code. And so for the customary legal system, you found that they adopted the customs that they thought were morally appealed to them. The standard they had was if a custom was repugnant to justice and morality, they oppressed it and in a way tried to erase the same. But also this repugnance to justice and morality was a standard that they set. So you find that the laws that we have right now, even our own understanding of our customary laws and African values and systems, it's time we start questioning that. Are they really our own, or is it something that we were taught? That these are our own values. So for example, for the families, the British, in establishing their rule, they created very neat structures. They removed the definition of family from a social negotiation to something that now had a legal conception. And that meant that they had to give it a very lean definition. For example, in Africa, Kenyans were polygamous by nature. But if you look at the current laws that we have, a family is a nuclear heteronormative structure, and even children are biologically reproduced in the entity. It is just recently that the Children's Act actually came in very strongly to even recognize adoption as a way that children can be born into families. So they're not organic. They were impressed upon us. Yes.
And it's very interesting that you said that. And as we were talking, I just remembered that we have a witchcraft act.
Exactly.
We have a witchcraft act in Kenya.
How do you go to court to prove witchcraft?
Exactly. And I was just thinking maybe they saw us doing our own, going about our customs, and then they thought, okay, now these people have to have some law that should guide, put them in a box, and that's how they came up with the witchcraft acts. Because I don't understand how we have that as a law 60 plus years after independence.
And maybe just to add, it would be interesting. I think I'll go back and check if we've ever had that mentioned in any case in court. It would be an interesting research area. I've just also remembered that the influences of religion, because Islam and Christianity also were brought upon us. And of course, it's not such a bad thing, but also we have to be very critical in terms of how we look at Christianity and Islam. You find that some of the things that we also do right now, or some of the ways that we define family, or how the law defines family, it borrows very heavily from religion. So you'll find that for Christianity, again, the heteronormative nuclear family where children are biologically reproduced and leadership is patriarchal, where the man is the head of the house. It also comes from a Christian perspective. And also for Muslims, you'll find that they had a very codified system of defining a family. So it's a man with 4 wives. They defined how divorce would look like. They defined inheritance. And as we'll speak later, we'll find out that it's just recently, actually, that the Supreme Court said children born out of wedlock are also entitled to their father's estate. But now when you compare this with the African system, where for us, children are communally owned, yeah, we were not saying you were born out of wedlock and things like that. So it's very important for us to look at the law from an intersectional viewpoint, yeah, not just as the law, but also the influences of other social issues, yeah, or the social ecosystem that we live in, yeah.
And so what I'm hearing from you is that the laws that we have actually not ours. Let me say that they're not ours.
They have
the wording of the British. They have religious influence. They have, customs from other people. And then they came, colonialization happened. Then here we are, we're having all these laws and policies that are really not ours, although we are calling them ours. And this has been the situation for a very long time. But then we have the current constitution, which for me is, I have to say, I love our constitution. I think it's one of the best constitutions we can have. And I was just attempting to reconcile the two. The fact that we had all these laws borrowed from, the British and being external, and them not taking up the African way of living. But then when you look at the constitution, it's progressive. It's progressive, but you can also see hints of the real African culture through the constitution. So how did we end up having this constitution? How did it end up embracing or having aspects of the African culture?
Good question. So you find that the committee of experts, when they were drafting the constitution, first and foremost, before going into that, I would want to put it out there that the constitution is a national document. And it's very important that it reflects the spirit of the people it governs. Something that in social foundations of law class we call the zeitgeist or something like that. It's very important that it captures that spirit of everyone. And Kenya is a very culturally diverse country, 42 tribes. So at the time of drafting the constitution, we saw very regionally focused blocks, from the committee of experts in terms of just understanding what is it that people from Western Kenya do.
Maybe just committee of experts. What is?
The committee of experts is a committee of legal experts. I'm trying to simplify it so much and not go into jargon. It's just a group of people who wrote the constitution, basically. And of course, they were very critically handpicked. They were handpicked. We got the best of the best people who have that kind of expertise. So when they were drafting the constitution, we saw a very regionally focused drafting. As I said again, there was very intentional. There's a lot of intention in terms of just getting to understand the different people, the different tribes in the country, the different regions. What are their beliefs? What are their customs? What is it that they would want to see in a law? Because also one of the sources of law is customary law, and it's very important to be able to. It's very important to represent the people in the very laws that govern them. And so I remember even the constitution itself was translated into so many languages, the first draft, and people got to read them. And there was a lot of focused campaigns even in the vernacular language radio stations to just create awareness and to be able to collect the views of the different people in terms of, the final provisions of the constitution.
And so, or what you're trying to say is that the committee of experts actually had to really consult the different tribes that we have as a country.
They went around the country.
Collecting views and infusing that to the constitution that we have now. Okay, that makes sense. Maybe that explains how we have a constitution that actually reflects the tribes and all that. And now that we have that constitution and it reflects the Africanness, it reflects our real African values and our customs and what we intend as a people to be. Like I said, when you look at it, it's very progressive. So it's also quite progressive on families specifically and other issues that were maybe not tackled as well before the constitution. And I'll go out here and just say, for me, I think it's because they actually consulted. They consulted widely and they consulted on Africans to see what our real values are. So looking at that constitution and looking that it gave us quite very many rights that were not there in the previous constitution, which was actually the previous constitution was 1963.
Colonial, really.
Exactly. It was basically from the colonial laws and everything else, and then we turned it into a constitution. So the current constitution that we have is actually the constitution that reflects Kenyan views, actually, and
our
African
lived experiences.
Exactly. So looking at it, it comes up with very many rights in terms of families, in terms of the role of women and equality, in terms of children, like you said, with the Children Act, in terms of bringing children to be not considered, whether you were born out of wedlock or not, doesn't matter. It came about to bring quite a number of other rights, including reproductive rights. Maybe you can just expound on those sections of the Constitution or articles of the Constitution and how that represents, progress in terms of us as a country.
So the Constitution, as you said, it gives us a very broad, a very transformative and a rights-based approach. And it's in Article 45 that it talks about the family, and it mentions the family as a natural and a fundamental unit of society. But then again, you'll find that you cannot read the Constitution in isolation. You cannot read Article 45 in isolation, because implementing it requires you to look at the whole ecosystem, the rights that are envisioned within the Constitution. So we look at Article 27 that speaks about equality and non-discrimination. And in the context of family, you'll find that this talks about, for example, you cannot discriminate against children based on their birth process. You cannot discriminate, let's say, on a woman based on her marital status and things like that. We are talking about Article 28 on dignity. You cannot operationalize families in a way that is degrading or humiliating to any particular person. We're looking at Article 31 on privacy. Are you respecting someone's conception of a family and what they do within that particular unit? We're talking about Article 33 on expression. How is it that I am expressing my own cohesion or my own understanding of family? Is it limited? Is it narrow and rigid, or am I free, to just express myself within my understanding of that and within the unit? We're talking about Article 43 on the right to health, and of course all the other economic and social rights, rights to housing, right to water and sanitation. And it's important to note that Article 43 on the right to health provides also for reproductive health. And there lies a very subtle acknowledgement of the place of reproduction also in families. We're looking at Article 210. Is it 210? Yeah, it's Article 210 on talks about a purposive interpretation and a holistic interpretation of the Constitution. So it's also talking about Article 53 on the best interests of the child, which moves now issues of child protection from adult moral frameworks to focusing or emphasis on the rights and welfare of the child. So you find that the current Constitution gives us a very, very broad framework. And of course, the articles do not exist on their own. We have other acts like the Children's Act. We have sections of the Penal Code that criminalize violations of some of these rights. We have some of the policies like the National Family Promotion and Protection Policy, which we'll discuss in depth in a few and be able to see both the pros and cons of it. So yeah, it's a very, very progressive constitution, as you said, and yeah.
No, actually, as you were breaking that down, I was just thinking like, wow, we have a constitution that really thought of everything. And I love the part that you've said about the interpretation of the Constitution, that it was supposed to be interpreted broadly to include everyone and not strictly to malign people or the likes. And I note that in your assessment of the Constitution, that you have brought in the aspect of the fact that the Constitution in itself, and correct me if I'm wrong, the Constitution in itself was not seeking to limit family in the way that we are attempting to, or the way that we actually do. You know, it did not seek to limit families. It did not seek to limit some of these rights. It sought to actually have a family supported the way in the African sense it was supported. So
actually, it's interesting that we brought this up because I think the other day it also came up among the questions that were being asked the Supreme Court nominees on Article 45, and there's been a lot of discourse on it, about it online. And my 2 cents on it will be the drafters, the committee of experts, were very intentional about not defining the family very rigidly. And this is because, of course, the Constitution itself cannot contain all the definitions because society, again, is dynamic. Today we have this, tomorrow we have something else. I would want to think, so of course it talks about, if you look at other laws, like maybe the Marriage Act and whatnot, they give a very, I want to say, a skeleton of what a family should look like. But again,
yeah, so we were just looking at how the Constitution is broadly defines families.
Yeah, it broadly defines families, as you've said. It is not limiting. It just recognizes a family and provides a framework within which you can operationalize the families.
So it includes everyone. It includes if we're looking at in the sense of people, intersex persons.
Exactly.
It includes marginalized persons.
It talks about persons with disabilities. There's an express, of course, recognition of women. There's an express recognition of children. And there's, of course, a very subtle recognition of these other units that make up this Article 45. Yes.
Okay, and there's something that you've said about the Constitution and or how we know the Constitution. We know that it's the backbone of the laws of the country. But then we also know that it needs other laws to make it operational. Basically, what that means is that we have the Constitution, but there needs to be other laws, like as she's mentioned, the Marriage Act, the Children Act, to actually give more meat. I always say that, give meat to the Constitution. I always take the Constitution as, you know, like the backbone, or what they call the vata what?
The spinal cord.
Spinal cord. The spinal cord. And then the Constitution is all this. Now you're trying to bring in the organs and everything to make the body work. And with that, we see that it brings in other laws that need for it to function, right? And in bringing in these other laws, are these other laws always reacting to what the Constitution wants? Maybe to put it in another way. When we come up with these laws, or as from your experience in Kenya coming up with these laws, are they always coming up with laws that are meant to respect the Constitution and ensure that people enjoy the rights as per the Constitution? Or or are there laws that sometimes do not always go with what the Constitution wants? How does that look like? What then happens?
Well, right. That's an interesting question. Again, if you look at the Constitution, again, as we said, it was developed at a time where we had just literally transitioned from the colonial constitution, for lack of a better word, straight to the Constitution 2010. And you find that there were a lot of provisions back then that we had internalized as a people because that is what we knew. And so one thing with transitions is we start with fighting about the definitions. So what does family mean in the Constitution 2010 that it did not mean in the 1963 Constitution? And you'll find that now there are laws that will be developed most of the time, but sometimes they're consistent with the Constitution, sometimes they're not. And it always comes back to the definitions again. How do we understand the particular provisions of the Constitution of Kenya 2010? And then again, sometimes these laws may seek to advance the spirit of the law, maybe the intention of the law, but then they do not do it in a way that is consistent with the letter. So the letter is the law itself. So for example, we look at, let's say, the Family Protection Bill. Of course, it is a good law. Article 45 provides and recognizes families. It is good to have a law in place that will protect the structure, a structure that has been recognized as very fundamental to the Kenyan society. But then when you go down to the provisions, you find that sometimes it veers off from the protection into maybe criminalizing.
So you've mentioned protection. So that should be the family protection and promotion policy for the bill.
Okay.
The
Actually,
policy.
both, but the family. In this one, I was actually mentioning the family protection. Let's say the bill, Basi, the family protection bill. It is a good bill because it has provisions that speak to very interesting or core tenets of a family unit. But then again, at some point, it veers off protection and goes into exclusion of things of marginalized populations and exclusion of structures that was not intended by the COK 2010. We look at the family protection promotion policy in itself. A very good document provides for even multi-sectoral support for families on health education and even recognizes different forms of families. But then again, you find that the policy speaks about, let's say it uses African values and Christian values in a way that is almost synonymous and is still not consistent with the Constitution 2010. And even in its recognition, you find that it is very abstract. There is no legitimate follow-up on ensuring, let's say, for example, the rights provided for in Article 43 are being accessed by these families. So in situations, there are situations where laws that are developed are not, of course, in tandem with the Constitution. And I think as we'll discuss later on, we'll find that there are also remedies that you can apply in such a situation.
But while we're still there, the family protection and promotion policy, which is a very interesting policy. Maybe that's why I want to dwell on it a bit. We do know that it was, first of all, I don't even know whether I want to go into how it was passed, because then we woke up one time and we found this policy in place. But like you said, it's not an entirely bad document, but there are aspects of it that are very limiting. And from my own perusal, just from my angle and looking at it, and we were looking at issues on how it was tackling or how it was not acknowledging that there are single parent homes.
Exactly.
How it was not acknowledging, or rather trying to advise or go with the notion that domestic or gender-based violence can be resolved within the family system, as opposed to what we have in terms of the court. We're looking at a policy that really was, as you said, taking a Christian angle to it. While we do know that in Kenya we have various religions, so we have those who do not ascribe to any religion. We are looking at a policy that's not really acknowledging the place of reproductive health or respecting the place of reproductive health in in the formation of families, and also looking at children or trying to remove children separately from issues on reproductive health again, and also not acknowledging child-led homes in terms of African, or in terms of families. But then we see these are the realities that we have right now as a society, and we are seeing that, like we said, the Constitution was set there to be a reflection of everyone in society, to be a protection for everyone in society, and to represent the rights of everyone in society. But then we are seeing a policy that is not acknowledging some of these realities of how we are right now, or what has happened, because we are acknowledging that we're no longer living as we did in the African systems. Even the way the economy does not allow us to still live in our households and to have that wholesomeness of all of us being together. So we're having laws that are not really reflecting the Constitution. And we're having laws that are not reacting to how the Constitution was. So how does then this affect those who are left out? How does it affect those who are left out, who are not represented within these laws that is supposed to reflect the Constitution? How then or maybe you can just give, not really even going to remedies as such right now, but how do we come up with laws that are not responding to what the Constitution is saying, and what does that mean for those people who are left out in such laws? And even looking at the family protection bill. There's so many, I keep forgetting. I think there's one called also Linda Jamii or something like that, where we are having a bill that says from the onset of it looks like it's really protecting families and the likes. But then when you go into the provisions, then it's creating, alienating some people, it's criminalizing some people, it's just creating discourse and moving from the spirit of the Constitution. How do we end up with laws like that, and who are most affected by such, alienation?
Okay. So how do we end up with laws like that? I'm just thinking, and I'm like, the sources of law and how to originate bills. That is the conversation in my head right now I'm having myself. Of course, you'll find that sometimes something like the National Family Protection and Promotion Bill was an initiative of the executive. And most of the times you find that the laws that are developed usually reflect the person in office, the president, the values that are held by the presidency that is currently in government, the values that are held by, let's say, the majority of the representatives in parliament. And I think recently, or since, let's say, this government came into power, we've seen a leaning towards a bit more religious values. And that can maybe explain why we have something like the executive sitting down to give us a National Family Protection and Promotion Bill. And so you find that
so without really consulting.
Without really consulting, because even us, we just woke up and, as you said, we had the policy and we're like, do you guys even follow due procedure? When was the public participation? Where are the attendance sheets? Where are the rapporteurs' reports from these sessions, so that we know if we as Kenyans were actually able to contribute this document. And then again, you sit down and you realize that Kenyans could not have actually contributed this document because this does not reflect our lived realities. You cannot stand and speak about your exclusion or promote your exclusion in a document like that. Others, like the Family Protection Bill, I think they were supported it originated from a member of parliament. And sometimes you also find that, of course, there are also some anti-rights movements and groups that also support the development of such laws. So it's important for us as Kenyans to also be very vigilant and to know when such things are happening, because we find that maybe someone tweeted about it, someone spoke about it in passing. We need to develop that kind of vigilance to be able to just know what laws are being passed. And with the effects are enormous, again, because laws regulating families don't just regulate marriage. They regulate issues of custody of children. They regulate issues of inheritance. They regulate issues of access to education, healthcare. They regulate healthcare decision making. So sometimes you find that they even regulate issues of our own freedom, because if you're criminalized, if your identity is criminalized, or you belong to a population that is marginalized in a way by the law, that means you are excluded from the word go, and there's a negative bias on you as a person. So the effects are enormous, and most times you find that if we don't hit back, if we don't have sessions, if we don't have, let's say, sessions like this where we're able to discuss and let the public know about some of these laws, people will continue living in fear, and they accept those effects as part of their everyday life. Yes.
That's very true and very, I don't know how to say it, but the effects, as you've said, they are far-reaching, and basically you're removing a section of society. Or as I started saying, the law is determining who family is to us, which is very weird. I don't know whether it's the Bible. Where does it say man came before the law? There's something like that. There's actually a verse like that. Man was made for the law, or law was made for man. I think that is it. Law was made for man, right?
Yeah.
And now here we are having laws that are determining who is family to us. So that's very crazy. But then the funniest bit about how these laws also came about is that they tried to say that these laws are reflecting African values.
Exactly.
And like I said, we've had discussions with the traditionalists, with the Luo Council of Elders and other people coming in and telling us what African values are. And you can see what African values are, which was inclusive and broadly looking at the family. And then we're seeing these attempts, and also the Constitution, like we've said, is also broad. And then we're having these laws that are really trying to make the family be very linear, really guard against who can be and who cannot be, in families. And looking at it, then how then are we able to separate if someone is claiming that these are African values? How are we able to spot laws that actually really reacting to African values and laws that have like a colonial, how can I say, shadow behind them, behind the scenes? Yeah.
I think at some point when I was starting the podcast, the recording today, I had mentioned that it's very important to be very critical, of what we call African values. And that means very active questioning or even our own biases as people, asking, what is it that I think is African? And to even identify what is African and what is not, we have to look at it from a historical lens. What was our family back then? And we have to be very honest, about what that looked like. And sometimes it's very difficult to look at yourself and look at truths that may not be comfortable. For example, when you find that you hold a bias that is inherently exclusive or oppressive of someone else, but it's important to do that. For example, in a family, how did Africans define families back then? Was it nuclear heteronormative? No. Yeah, because even when you look at some of us, it's not a lot of it. It's around 60 years. Some of our grandfathers still have their 4 wives living in the same compound. We've grown up with our parents feeding from the same house. We've gone to our rural areas and eaten in houses of people we don't know because they're family and things like that. We need to ask ourselves, how was custody looked at back then? Did the children's system, were children only biologically reproduced, or was there like a kinship system? You find that how was caregiving? How did it look like back then? Was it very strict, but was it communal based? How was kinship ties and things like that? So we have to go back and look at the definitions of family from a historical lens and be very critical and be very honest. The conversation requires us to be very, very honest. If we look at African values versus the restrictive thinking right now, how do you tell the difference? You'll find that African values are grounded in relational, and they recognize the very nuanced and complex ecosystem of what a family is. But the restrictive thinking is very rigid, nuclear, patriarchal, children are biologically reproduced or maybe adopted right now as we're expanding the definitions to look like. You'll also find that the African system was very inclusive of everyone because people lived in communities and communities looked out for each other. But our systems right now are exclusive of people. It is as easy as that, just saying 1, 2, 3, 4 goes here, but here we have 1, 2, and then 3, 4 on a different set. You also find that African values were cognizant of, how do I say this? African values, for example, shared resources, but then we're looking at laws right now that are very key on ensuring that some areas or some people are marginalized and they're excluded from even accessing some of these services. So it is a very nuanced discussion, as I can say, and it requires that historical lens to be able to look at it. Yeah, so go back to history. 60 years ago, what did we say this was? But all in all, African values inherently, they were not exclusive. They were not oppressive of other people. And they did recognize that family transcended biological and genetic relations. Yes.
And I love that, and I love what you said about African, how to identify a law that has been influenced by African values is that it's complex. It understands the complexity of African living, and it has depth. Let me say that. So if we are seeing around some laws that are not having depth, are just
narrow definitions,
then we know the source.
Yeah, there is a problem.
We know the colonial source. So as we wind up the conversation, we have seen what the Constitution wants us to have. We have seen what, or have talked about all through the podcast series about what African values are. We have seen how colonial and religious influence can find itself within our laws. And we have seen that this happens behind the scenes, not obviously, like you said, you wake up and you see maybe there's a policy and a bill. And right now, as we're talking as a country, we know there's so many bills and policies being churned out every other day. and calls for, you see, public participation, then what are the chances of us getting involved so that we're not having policies and bills that are actually not reflecting our values? And now coming to the remedies, when we already have laws and policies that are not really reflecting our reality as Africans, or we're having laws and policies that are purporting to tell us what is African when we know what is African. How do we go about that? How do we go about dealing with such laws? And then how do we prepare for the future so that we're not caught off guard?
Okay, that's a very, very layered question. I'll start with how do we even know they exist? And so you find that one of the ways we can know that some of these laws exist is by being vigilant. It is our responsibility as a citizenry to know that this is happening and these are the laws that are being passed right now. So there's the issue of, right now, of course, we've seen a lot of digital platforms. It's up to us to be on the lookout about them. And nowadays people don't listen to radio or read the newspapers. Sometimes they hide those calls for public participation in the middle of the papers so that we can't see. But also on the vigilance beat, how do we even know that this law is good or bad? And so I think the first thing we need to do when there are laws like that is look at the definitions. Our vigilance should send us to look at the laws themselves, and we look at the definitions. How is this defining a family? How is this defining a marriage? How is this defining a child and a custody system? Because most of the times we find that that definition is what lays the groundwork for the exclusion in the succeeding provisions. Number two, look at who is missing. It's very important. Who is missing? Looking at who is missing also enables you to be able to know what is the cost of passing this particular law. Who is missing? Sometimes they can define a mother and a father, but they may leave out an intersex definition of the same. So how does an intersex person fit into the definition of a mother and a father, considering that they do not fall in the normal gender definitions? Maybe they can talk about mother and a father without talking about guardianship and foster parents and things like that. So who is missing from this conversation? Number three, you need to look at the criminal liabilities imposed by that particular law. Who is being excluded, and not just excluded, but who is being excluded and targeted by this particular law? That in itself sometimes can help you understand how to even know, let's say, how to even approach maybe your advocacy surrounding it, or even what to do in a petition if you are to do one. Another is also be very careful about the language. Law is literally, usually say we are paid to speak English, and a lot of power resides in legal provisions, in those very subtle statements and that are hidden. So look at what is the language used. For example, family protection. What is the family unit it is protecting? So that takes you back again to the definitions. What is the cost of this particular protection, both positively and negatively? It's very important to be able to look at the language and the context of use. And I think lastly also, as we talk about vigilance, it's just important to try as much as possible to know what is happening. We're living at a time where we cannot afford to be lax about our laws. I think, I can't remember who the originator of the proverb is, but they say they came for the farmers and I did not cry because I'm not a farmer. They came for the, let's say, teachers and I didn't cry because I'm a teacher. But tomorrow they'll come for you. So it's important to be able to ensure that whatever laws that we have, even as you look at the vigilance, they are consistent with the provisions of the Constitution. Article 27 on equality, 28 on dignity, 31 on privacy, 33 on expression, 53 on the best interests of the child, 43 on the economic and social rights. Are these laws consistent with our backbone? That's on vigilance. And maybe to just speak on how can we engage. Of course, there's public participation. And we had a case, of course, where the Supreme Court said it should not be a ticking boxes activity. The government should take into consideration, whatever arm of government, both the county and national government, they should take into consideration the views that we give, and they should positively, of course, influence the particular policy or laws. But then again, of course, in as much as our views are not binding, it's important for us to subject ourselves to the process, so to ensure that the laws and policies that are passed reflect our interests and our lived realities. It is very important that the laws serve us, as opposed to the other way around. Another way to engage is to petition Parliament on some of these things. it is in law that we can petition Parliament to relook some of the provisions and bring to their attention things that may not be consistent with our lived realities of the Constitution itself. Another way to engage strategic litigation. Let's go to court about these laws, because the judiciary provides interpretation for our laws, and they also provide direction in as far as legislation is concerned. We saw that happen with the finance bill. We've seen that happen with the abortion case that has been in court recently. So it's important, go to court with them. And even on issues of marginalization, we have the Eric Gitari case, for example, where the Constitution said, where the Supreme Court said, we're not going to limit your right to association because of your identity. That is a right that is inherent for you as a Kenyan, despite your identity or who you are as a person. So go to court, strategic litigation. And you'll find that there are so many, let's say, organizations or persons who are willing to support the process, very many lawyers, media houses, and things like that. Other will be, let's call our MPs and our MCAs and send those messages and emails, and just remind them and tell them, this law is coming up before the county assembly. This is what we want, spoken about it. That is also one way of engaging with these particular laws, because democracy in Kenya is representative, and so they're better placed to actually voice our concerns than we are. Yes.
Thank you very much. I actually don't think I have anything to add in terms of how we engage with this, the legislative process, and how to push back on laws and policies that attempt to take us the colonial way instead of the African way and the constitutional way. So with that, I will just give you a moment to give us a parting shot, hot parting shot for us in terms of African values, and in terms of the legal system, and in terms of the Constitution, and as ensuring that our laws are speaking to the true African values that are not influenced by westernization, and that they respect the Constitution and go back to the Constitution.
Okay. I've been requested to give a hot parting shot. Let me prepare myself for that. So in conclusion, what I can say is this is our country. This is us. The Constitution vests sovereign power on us as the people. All power belongs to us as the people. Let us not leave lawmaking to persons who may not understand our context and our lived realities. It is up to us to take charge, to pick up the mantle and take charge, be part of the process. We cannot afford to be lax about these processes anymore. And also, just to, not the parting shot for real, African values were inclusive, and they recognize the complex and nuanced way that we lived and even coexisted with each other. So it is important for us to ensure that the laws that we develop now are inclusive and they recognize the complexities of our relationship. Yes.
Thank you so much, Beth.
Thank you.
This episode of this podcast is sponsored by KMET, an NGO, an indigenous NGO based in Kisumu, but working in the Lake Region Economic Bloc and other counties in the north, and basically 44 out of 47 counties in total. Until next time, bye.